Every year, thousands of lawsuits are filed alleging civil rights violations by the police. The Marshall Project reported only about 5% of the plaintiffs claiming abuse actually get their day in court, but only a third of those actually win. The organization takes a look at one incident where officers held down and tased a teenage girl while she was having a seizure. It took 7 years for her case to make it to court, only for a jury to side with the officers in the end. Joining me now is Wendy Ruderman, a staff writer with the Marshall Project, and trial attorney Gregory Harp with Gregory Harp, LLC. Thanks to you both for coming on tonight.
Thank you.
Greg, to you first. You represented Tierra, the teen who was tased while having a seizure. And like I mentioned earlier, it took 7 years to get the case before a jury, and in the end, they voted to acquit the officers involved. Can you briefly go through how this case unfolded?
Sure. The initial lag time that it took to get the case to trial, which the case going to trial was somewhat of a feat in its own, because normally these cases never make it to the trial stage. We spent at least 3 years fighting the qualified immunity issue because the case, there was a summary judgment sought in which the officers sought to have the case dismissed on qualified immunity. And then we had to appeal. We had to fight the appeal after they lost the summary judgment. And so we ended up spending an enormous amount of time just fighting the qualified immunity issue. Once we got it to trial, it became an issue of jurors who decided that they did not want to hold police officers accountable regardless of underlying facts.
Wendy, you know, people, especially in the year 2020, when police departments across this country were facing a reckoning, so to speak, you heard this term qualified immunity so much. I don't know if a lot of people even understand what it is. First, can you tell us what qualified immunity is and how it protected these officers from liability?
Yeah, so I actually had to learn a little bit about qualified immunity for this case. It's a little bit more complicated in some regards, and Craig can talk about that. But basically, it's a legal doctrine that shields police officers from being sued for their actions while on the job, except in really rare circumstances, pretty egregious circumstances. And in order to overcome qualified immunity, civil rights attorneys like Gregory Harp have to prove that not only was this unreasonable, the actions of the officers were unreasonable, but that they should have known that it was unreasonable based on a prior decision or based on case law, which is just such a high bar. And defenders of qualified immunity argue that it's needed because it allows police officers to do their jobs without fearing that they will be bankrupt or saddled with lawsuits, and that it's a necessary protection. But, you know, I think Supreme Court Justice Sonia Sotomayor, who's considered a liberal, really summed it up. She's pushed back on qualified immunity, and in a dissenting opinion, that had to do with police use of force, deadly force. She famously summed it up that by the federal courts keep upholding qualified immunity, it's sending a message that officers can shoot first and think later. And that phrase kind of stuck in my head when I think about qualified immunity. What was interesting about Tierra Helm's case, the 17-year-old who was held down and tased by police while she was either coming out of a seizure or in the midst of a seizure, was that her case was one of the very, very rare cases that overcame this hurdle, and her legal team just kept fighting it at every step in the process, and that's in part why it went on for 7 years, but ultimately they won. And what struck me about it was that the appeals panel who heard the final arguments and upheld the case and allowed it to go forward, they were pretty vexed. You could hear in their oral arguments how indignant they felt about this case. So that was interesting.
Greg, law enforcement, or the law enforcement community and proponents of qualified immunity say that it's essential for officers to effectively do their job. In fact, the legal doctrine is one of the reasons why the George Floyd Policing Act wasn't passed. Can you explain why they take this position, and do you even agree to some degree?
No, I don't agree, and therefore cannot explain why they would take that position. The doctrine is just that, it's a doctrine. And in 1967, like most cases that went before the U.S. Supreme Court during that time, it had a race component attached to it, where the 15 priests in Mississippi were arrested and sued under what was then called the Ku Klux Klan Act. And the Warren Court, overturning the Fifth Circuit Court of Appeals, said that officers are sometimes allowed to make those decisions and conduct those actions, and that they may have some protection, some immunity to it. And the Supreme Court has taken that throughout the years, and they have began to mold it into something that, again, there is no legal basis for the doctrine of qualified immunity. And Justice Thomas, whom I rarely agree with, actually called that to the court's attention as recently as 2017. As an originalist, he stated that there is no legal basis for this doctrine that we have created through our rulings. And so it becomes counterintuitive to say that this will help us police better, because what it actually does is act as a sword rather than a shield for those police officers who do not conduct themselves in a manner that police officers should conduct themselves.
Well, Greg, you've sued police departments for years for violating people's civil rights. How has qualified immunity made it so hard for people to win excessive force lawsuits?
Because the doctrine of qualified immunity states that if I sue a police officer for bad conduct, that police officer has to be on notice for that his or her conduct was bad, was unconstitutional. And the only way that that police officer can be on notice is if there is an existing case already published by the U.S. Supreme Court or the appellate court in the municipality's jurisdiction in which that officer works, that put the officer on notice that his or her conduct was unconstitutional. And so the problem with that is that if you're the victim of unconstitutional force by a police officer and your fact pattern has not been decided by a court, be it the U.S. Supreme Court or, in my instance, the 11th Circuit Court of Civil Appeals, then there's no existing case law that would have placed that officer on notice. Therefore, that officer is automatically entitled to qualified immunity. With the caveat being
Wendy,
I'm sorry. I was just going to say, there is a caveat, and there is a carve-out that says that if the acts are so egregious that any reasonable person would have known that, then you may be able to escape the clause of qualified immunity in that situation, which is extremely rare.
Wendy, we're talking about this, in a bigger context, but specifically about Tierra's case. You've spoken to her after you published your piece. Can you tell us how she's doing?
Yeah, she's actually an extraordinary young woman. She said that she was really glad that she went, even though it was very punishing for her to go through the trial and to fight so hard, and then to lose after 7 years. She felt like that if she hadn't brought this case, she would have never. She would always second guess the decision. She said that she just wanted to be heard, and she actually said that she really would have just accepted an apology from the officers, and that it was horrible to sit there after 7 years and for them to continue to point fingers at her as if she had done something wrong. But in the end, I think speaking to the Marshall Project, she did say that it provided her a measure of closure and a way for her to be heard. And I think that she didn't have any remedy besides the federal court in terms of trying to get some justice for herself. And then when that didn't work, and it essentially came down to the jury, she did talk to me, and I think she felt there was a measure of closure in being heard. And she was thankful, and I was gratified as well. She's really something.
Wow. Attorney Gregory Harp and Wendy Ruderman with the Marshall Project, thank you both for you coming on tonight. I appreciate your time.